Good afternoon. Today I have a pleasure to interview Professor Marco Sassòli, who is a professor of international law at the law faculty of the University of Geneva, and he is also teaching the core course of IHL at the Geneva Academy on Human Rights. Professor Sassòli was the director of the Geneva Academy between 2018 and 2020. Currently, he is also a commissioner and a member of the executive committee of the International Commission of Jurists. In the last century, Professor Sassòli also worked extensively with the International Committee of the Red Cross and held various positions both at the headquarters and in the field. More recently, he was a member of a mission of experts under the Moscow mechanism of the Organization for Security and Cooperation in Europe, inquiring into violations of IHL and human rights in Ukraine that took place between the 24th of February and the 1st of April 2022. Professor Sassòli, thank you very much for being with us today.
Welcome.
And I would like to start our interview with the very first question, knowing that you are the expert in IHL. And what does it mean for you today to be an expert in IHL? Well, in recent years, we have seen the escalation of various protracted conflicts, for instance, in Syria, Ethiopia, Yemen, reopening of hostilities in Armenia and Azerbaijan regarding the Nagorno-Karabakh, also the fightings between Taliban and the former government of Afghanistan, and of course the international armed conflict that shocked Europe today, the conflict between Russia and Ukraine. Do you think that IHL is regaining its importance and relevance nowadays, and there is a growing demand for the specialists in the field?
Well, first, I'm not sure that there are more armed conflicts today than previously. One always idealizes the past. But indeed, there is much more interest, and this is good for international humanitarian law. You know, and I started to deal with humanitarian law in 1985. There were only a few specialists at the ICSE and some military. And there was only one course in a civilian university, in my university, on humanitarian law. Today, there are hundreds of courses worldwide. The training of armed forces has improved. Diplomats know IHL, and even the UN Security Council commits less mistakes in IHL in its resolutions than, say, 40 years ago. So there is increased interest, and indeed there are more experts, including thanks to the Geneva Academy, which, if I may say, produces some 40 to 50 experts per year, and when I travel I see them everywhere in the world. And other universities also train people in international humanitarian law. Still, there is need for more expertise, because we see that in public opinion and sometimes even by states, fundamentals of humanitarian law are not yet understood. And these are unfortunate fundamentals, because humanitarian law applies to armed conflicts, and therefore it tolerates a lot of terrible things, like civilians are killed, and this is not always a violation of humanitarian law if they are not targeted, and civilian infrastructures are destroyed, and this may be in conformity with humanitarian law as long as they are not targeted and they were not military objectives, and this is often not understood, and therefore we need more people who understand this and who make the right arguments about humanitarian law, because there are a lot of controversies, but not those controversies which often appear in public opinion.
Thank you very much, and you brought a very important point here. So the growing interest also somehow provides for the growing criticism of IHL, because more and more people pay attention to how the conflicts are being conducted. Media is also playing an important role, demonstrating all type of just horrifying images, and I think also the outbreak of the conflict in Ukraine demonstrated that there are a lot of misperceptions about IHL, and namely many argue that it is unacceptable and even unrealistic that IHL equally applies in the same way to the both parties. In other words, that the law somehow treats equally the aggressor and the victim. And in the public opinion, this conception does not find the proper place. What do you reply to this criticism?
First, about violations of humanitarian law, we have to be conscious that humanitarian law provides only a necessarily insufficient minimum of humanity in a profoundly inhumane situation, which is armed conflict. And therefore, it is not astonishing that in such a situation there's not a perfect respect of the law, because if there was perfect respect of the law, and this already moves to your second question, there wouldn't be armed conflicts. One also has to say that the perception is worse than the reality, because understandably the media and NGOs, they report about violations, and the very good phenomenon of the increase of international criminal justice, obviously they deal with violations, not with respect. And therefore, in public opinion, there is often, especially in third countries, which are fortunately not affected by armed conflict, the impression that anyway international humanitarian law is always violated, which is wrong. In the last century, when I worked for the ICSE and I was in the field, even in such armed conflicts like between Iran and Iraq, or in the Israeli occupied territories, or in Bosnia, there were many instances of respect. And I think it would be very important that one also reports about respect. Since the 24th of February, when the war in Ukraine increased, I didn't see any media report about the case of respect. And this can lead to a self-fulfilling prophecy, because no one wants to be the only idiot who respects IHL if he or she is convinced that everyone else violates IHL. So we should also show that IHL often works, and we do it in our classes. And perhaps now, to speak about your very justified remark, I always considered, but now I'm even more convinced, that the most difficult message to bring over is that humanitarian law applies in the same way to those who are right and those who are wrong. And this is always unacceptable for the victims to tell people, I don't know, I started with the conflict in Iran and Iraq had attacked Iran. And the Iranians said, yes, we like humanitarian law, but you must take into account that we are the victims of an aggression. And when I told them, yes, but you have to comply with the same rules, then your enemies, the Iraqis under Saddam Hussein, they didn't appreciate it. But now, with the Russian aggression against Ukraine, this has become worse, because even other states and in public opinion, when I, for instance, say, which is correct in humanitarian law, that as long as Ukrainian forces defend every house in Mariupol, Russian forces may attack such a house, this sounds shocking. Which is understandable, because obviously if Russia hadn't attacked Ukraine, there wouldn't have been any of these destructions and sufferings. But it is essential for humanitarian law that it applies to both sides the same way, because in every single armed conflict, both sides are totally convinced, and those who fight for a side are totally convinced that they are right and their enemies are wrong. And so if we had different rules for those who are right and those who are wrong, we would never be able to have IHL respected.
Indeed, but still we have to admit that violations do happen. And yes. You have worked a lot as an expert with various international organizations and mechanisms. What are in your opinion, the most effective ways for enforcing IHL? So, for instance, we see a growing number of independent commissions of inquiry, like one in Syria or the one that was recently created for Ukraine. Human rights mechanisms, they also deal with human rights violations in contexts of armed conflicts, like, for example, the European Court of Human Rights in Georgian and Russian case. The other obvious example is the International Criminal Court that starts investigations for such conflicts as the one in Afghanistan or the Palestinian context. Do you think these are efficient mechanisms to bring forward the enforcement of IHL?
Well, when it comes to enforcement, we have to be conscious that humanitarian law is a part of public international law, and this is the weak aspect of public international law, not because of those who developed public international law didn't want to have enforcement, but because states, and I would argue peoples, do not want to have a world state, a world police, an ordinary world court. And so the same frustration exists concerning international trade law, the law of the sea, and so on. Now, in humanitarian law, it is perhaps even more conspicuous because it applies to a situation where there is already violence and suffering. Personally, I think the most promising avenue is prevention. Training of people, this is what we do in the Geneva Academy, national legislation, training of armed forces, explaining the law, but obviously to establish the facts is a very important thing because, and here I think there is a certain increase of manipulation of facts or simply stating counterfactual so-called truths. And in most cases, the controversies are not really about the law, but are about the facts. And therefore, impartial inquiry is very important also to set the record straight that certain things did not happen, that certain conduct was not a violation of international humanitarian law. There is a positive development that, for instance, the Human Rights Council created more and more systematically commissions of inquiry as soon as there was an international or a non-international armed conflict somewhere. They created a commission of inquiry. Obviously, such inquiries are incredibly difficult to really establish the truths, although to establish the truths about violations of humanitarian law is much, much, much easier than to find war crimes, because war crimes are committed by individuals, and so you have to find an individual with a first name and a family name who is responsible for a certain violation. And in addition, the burden of proof is much more, rightly so, much more heavy, in the sense that you cannot simply by plausibility arguments sentence someone to life imprisonment. You must prove it, which is very difficult, in particular if the parties do not cooperate, which most of the time they do not. But international criminal justice, and I would add and emphasize domestic criminal justice, is very important to show that all these are not nice wishes of professional do-gooders, but are legal rules, and those who violate the rules will be punished. The International Criminal Court can only take very few cases, but it's symbolically important, and it is good that now domestic courts, both in warring countries and in third countries, thanks to universal jurisdiction, take up more and more cases. But just like in every state, you cannot make the social system work through criminal law. There must be a willingness of those who are the addressee, in most cases, to spontaneously comply with humanitarian law, and the first step is to understand humanitarian law.
Since we touched upon this issue of prevention, enforcement, involvement of third parties in prevention of violations, I cannot avoid asking the question about obligation to ensure respect under Common Article 1 of the Geneva Conventions. A couple of years ago, the discussion was taken the direction that states were somehow reluctant to recognize the legal nature and the legal force of this obligation. Since the conflict in Ukraine started, the situation has completely changed. Do you think the states are reconsidering their opinion, or this is more a specific example for a specific conflict?
I hope the first answer is correct. I fear the second answer is correct. But even if the second answer is correct, this is a precedent. And the force of the law is when you claim that something is a legal rule, then it will also apply next time. And states and public opinion will be embarrassed if not at least a similar, and you are right, it's unprecedented, the efforts to ensure respect of humanitarian law. If a similar effort is not made when the victims have a black skin or are Arabs and so on. And obviously the case of Ukraine is complicated because the unprecedented sanctions are not specifically about violations of humanitarian law, but also cover the aggression. The violation of jus ad bellum, and they don't really separate the two, but I have the impression that each time there's a new allegation of violations, the sanctions are added, which is a good thing, but obviously also means that those who want to have support by the international community have a certain interest to claim that all kinds of horrible acts occur, because then they get the support, which they would perhaps not get, as they should under public international law, by the mere fact that they were attacked.
And then now I would like to ask you something about the International Committee of the Red Cross. Since the outbreak of the conflict in Ukraine, the ICRC was subjected to a number of criticism and misinformation in the online sources, and mainly it started from lack of condemnation of the outbreak of the war, and then also the president's meeting with the president's Peter Maurer meeting with the Minister of Foreign Affairs of the Russian Federation, Sergei Lavrov, created a lot of resonance in the public opinion. Do you think that there is a complete misunderstanding of the mandate of the ICRC nowadays?
Unfortunately, I fear that the ICRC is in a very bad situation. It has always been essential to meet both parties, and I mean, when I worked in the former Yugoslavia, I was proud. I'm today proud that I met people who later were found to be war criminals, because these are the people who have an impact on the treatment of the victims, and to have access you have to speak with people, with armed groups, with terrorist groups, with states who commit acts of aggression and so on. But the difficulty is now neutrality is seen as something nearly unacceptable, as if it was the first conflict in which someone is right and someone is wrong. Now, even Switzerland wants to abandon its neutrality. The problem is Switzerland can do that. The ICSE could never abandon its neutrality because it would have to disband itself. It has to be neutral, and it has to apply the law to both sides, and it has to have even more contacts with those who commit more violations than with those who commit less violations. And therefore, the fact, and you are right, that in public opinion this is somehow criticized, shows a fundamental misunderstanding of the very mission of the Red Cross, I mean, the ICSE started with the Battle of Solferino. Who has ever analyzed? I don't know who was right and who was wrong in the Battle of Solferino, but the women of Castiglione said tutti fratelli. And tutti fratelli means that we don't care of who is right and who was on the wrong side and who was on the right side, but indeed this is a great challenge. But I should add, okay, the ICSE, as you know, is very confidential, and therefore we don't know what they do and what they can do. But to the best of my information, they are able to fulfill their usual tasks in this international armed conflict between Russia and Ukraine. Simply, it has become more difficult to communicate this than, say, in my time about Iran, Iraq, where there were very little, too little, I would say, international passions about violations of humanitarian law, or even in the war in the former Yugoslavia, where there was a lot of information about violations, but I don't remember that the ICSE was ever criticized that it also had to negotiate with, say, Milosevic and Karadzic.
It's very interesting because we speak a lot about public opinion and how it's impossible to stay impartial with respect to certain questions. And now I just want to know, how does it feel to teach IHL in a very diverse environment? You have students who come from all over the world. Many of them also come from the countries that are affected by armed conflicts. Is it difficult to, first of all, manage to explain to them that how to assess the facts impartially, how to separate your feelings and emotions from the real factual evidences or circumstances, and finally, how to convince them that IHL actually works?
Well, I would start by saying, unfortunately, we don't have enough students from conflict areas, and if I had money, I would grant scholarships specifically to students from conflict areas, putting as a condition, then you cannot envisage a career with the UN or an academic career. You have to go back to your country and to work to implement international humanitarian law. But fortunately, we have some students from conflict areas, and there it is astonishing, because you're right, theoretically one would expect that this is a difficulty. I must say, I never had this difficulty. Those students, as we deal with cases from very many armed conflicts, somehow from the very beginning, they understand that they are not the only victims, which is often the case for the people who suffer on the ground, that they see only their victimization, while once one studies different cases from different armed conflicts, and one sees that the rules have to apply also in situations where your sympathies are different. Interestingly enough, students are very objective. I remember we always deal also with the arbitral decisions of the arbitral tribunal between Eritrea and Ethiopia. And you know, I was not able to distinguish the names between Ethiopian and Eritrean students, and they wrote papers about this conflict. I was a little afraid that they will write polemic papers, but I must say I was not able to distinguish who was who. And when I congratulated them, they answered, you know, we wanted to have a good grade and to understand the law, and we understand that it is not by attacking another side that we will better understand the law. And the other experience is, as you know, we have mock pleadings on this year, for instance, on 2 cases, the conflict in Gaza, some students representing Palestine, others Israel, the conflict in Georgia in 2008, some students representing Georgia, some students representing Russia, and they cannot choose who they represent, but we attribute them bite a lot, and in all my experience it happened only once that someone said, but I have difficulties to represent this party, and I explained them, well, precisely if you want to fight for your people, you must understand what are the arguments of the other side. I mean, lawyers prepare by saying, okay, now you play the other side, let's look what arguments could come up and how we could answer to these arguments. And as I said, it nearly always worked perfectly, and I'm rather positively astonished, and it shows that the students at the Geneva Academy somehow emerge in an atmosphere where it really is about the respect of humanitarian law. While there are often divergences of view between students who put more emphasis on the humanitarian aspect and other students who are more prone to understand that humanitarian law must remain realistic. While on the specific conflicts, it always worked well.
Thank you very much for this very honest and pertinent answers, and for being with us today, and especially for the fascinating work you've done.